Karen Sue Anderson with an O. I mean an E, A-N-D-E-R at the end. All right, I'm going to go and hang up here.
Okay. All right.
Bye.
Where do we put that at Karen Anderson part? Huh? Allow your viewers to request to join your broadcasters. Okay. Let's see. Hey, everybody. I'm Barb Mountain. This is Chris Doherty of Doherty Chillikeen. And we're going to be talking about Social Security disability. We're just having some technical issues. So let's see who we've got here. Let's see. Oh, there she is. All right, how can we share with her? All right. All right, Karen, we can see you. We're trying to figure out how to add you. Let's see.
Yeah.
Oh, guess that didn't work. All right. Plus sign. Okay.
Ask her, how do we add you?
All right, how do we add you, Karen? Trying to just go for it. Don't worry about me. All right. Hi, everybody. I'm Barb Mountain, and this is Chris Doherty with Doherty Chillikeen. We are a Social Security law firm that helps people get on Social Security disability. So we're here to answer any questions you might have about the process. So if there's anyone out there who has any questions, feel free to ask anytime. But right now, I think I'll turn it over to Chris, who can tell a little bit about the firm.
Thanks, Barb. Sorry about the technical difficulties. We had to kind of switch things around, and we're flying by the seat of our pants right now. But anyway, so yeah, a little bit about my background. I'm an attorney, and all I do is Social Security disability work. And my background is similar to Barb's in that I used to work for the Social Security Administration, taking disability claims. And I was going to law school at night while I was doing that, and now I'm kind of combining the two and representing folks, getting them entitled to Social Security disability. And one thing what I want you to do as we're speaking here is please type in any questions you might have, and we'll want to address your specific issues.
All right. So in terms of what is Social Security disability? For Social Security, a disability is something that's expected to last for at least 12 months or result in death. So it's not a short-term disability, but it is something that's expected to last for at least 12 months, which is commonly the case with aortic dissections and conditions that we're talking about. So it is something that you've paid for. Social Security disability is an entitlement program. So you pay for it when you're working, and it's your FICA taxes. And the reason why you're paying for it is you're paying for an insurance program. And the insurance is for benefits when a person's unable to continue working and going forward. So if you're unable to work because of your condition, then you should file for Social Security disability to see if you're eligible, because it is a program that you've been paying for. So again, it's something that's expected to last for at least 12 months and has resulted in the inability for you to be able to work full-time, or what they call substantial gainful activity. Chris, you want to talk about that?
Yeah, I'm going to talk a little bit about how Social Security makes a determination whether or not you meet their requirements, whether or not you are in fact disabled. So the first thing they look at is, are you in fact working? And Social Security defines, as Barb was just talking about, substantial gainful activity as any time you earn more than $1,220 per month, and that's gross. So obviously that's not a lot of money. If you're earning more than $1,220 a month gross, then you are participating in what they call or engaging in substantial gainful activity. I like to say, obviously, $1,220 a month is neither substantial nor gainful. So if you're earning less than that, or you're not working at all, then you meet the first step in the 5-step sequential evaluation process. The second thing they look at is, do you suffer from a severe impairment? And that's an easy hurdle to overcome. You only need to have something that affects your ability to do basic work activities. Now, the third thing they look at is, do you meet or equal in severity what they call a listing? A Social Security listing, when you're talking about aortic aneurysm, is found at it's listing 4.10 in the Code of Federal Regulations. And basically, I'm just going to read it to you because you folks, unfortunately, are too familiar with this impairment. Basically, it says if you meet this listing, disability is automatic. And that is if you have an aneurysm of the aorta or other major branches due to any cause. So it could be due to Marfan syndrome, or it could be due to a trauma, a bad accident, or heart disease, or high blood pressure, what it might be. And if due to any cause, it's demonstrated by, they have to have the imaging techniques like MRIs or CAT scans to show it. And if that dissection is not controlled by prescribed treatment. So then they talk about, well, what is prescribed treatment? And what do they mean by dissection not controlled by prescribed treatment? And basically, it's, of course, you guys know what a dissection is. And when it's not controlled means it could be growing. In other words, if in one image it's at one size and then it's growing in another, then that's not controlled. And so basically, as you know, this can cause many other problems, heart failure, kidney issues, etc., neurological complications, whatever it might be. So if you meet the requirements of this Social Security Listing 4.0, then disability is automatic. If you don't miss it, it doesn't mean you cannot get approved for Social Security, but rather it just means you don't particularly meet a listing. And then they'll look at other issues. And those other issues are, in step 4, are you able to perform your job despite your impairments? And if you can, of course, then they're going to say, well, you're not disabled because you can do your past work in their estimation. But if you cannot do your past work, then they say, can you do any other type of work that exists in the national economy based on whatever your residual functional capacity is? So that's kind of a rough overview of how Social Security looks at it. But if you're going to apply for Social Security disability, you can apply online. But the first thing I would do is I would approach your physician, and specifically, your cardiologist or specialist, and ask them if they would support your application for disability under Social Security. They know the requirements, they know your condition best, and if you can get their support up front, then go ahead and make the application. Okay, Barb, do you have anything to add?
Okay, you can read that question. So I would suggest if you are thinking that you're unable to work, you have a condition that you're unable to work, you expect to be out for at least 12 months, or you've already been out for 12 months, then feel free to reach out to us at Doherty Chelakeen. We're more than happy to answer any questions you have. There's no obligation whatsoever to use us as your representative. We're more than happy just to answer your questions and get you down the right path, whatever that might be. But if you did work with us, what we would do is we would complete the application with you, answer any questions that you have, fill out all the paperwork, request all of your medical, submit it to Social Security, and then we would work with Social Security through the initial application process. Hopefully we get you approved at the initial application level. However, only 35% of everyone who applies for Social Security is awarded at the initial level. If you're denied at the initial level, we go to the reconsideration level. At that level of appeal, only 13% are approved. So again, not a lot approved here. But then we're going to get to the hearing level. And that's where the majority of people are awarded Social Security. And that's where we go before a judge. We represent you in person and present your case the first time you're seen face-to-face by somebody. And that is where Social Security statistics are a 45% chance of award. We have much higher award percentages with the people that we work with because this is what we do all day, every day. It is something that really requires skill to understand how to present your case. So that's really important. But I would encourage you to not wait too long. If you feel that you're not going to be able to return to work within 12 months, you should get that Social Security process started early because of how long it takes to get awards. Social Security is not a speedy process. It can take a long time. And so you're going to need money. Obviously, you're not able to work. So you want to get that process started as soon as possible. So again, I encourage you to ask questions, to find out about the process, and to start it as soon as possible if you think there's a potential you won't return to work within 12 months.
I see there's one question on there that says, if once we're approved, why do we have to be reevaluated? That's the way Congress drew up the Social Security Act, and it says that once people are entitled to Social Security disability, by law, they must be reevaluated. And they'll put you, once you're awarded, they'll put you in 3 categories to determine when they're going to reevaluate you. The first one is if they expect medical improvement, they can reevaluate you after 1 year of disability. The second one is they'll reevaluate you after 3 years, and then the third one category is they'll reevaluate you after 7 years. So it's just a way to Social Security protect the trust funds that they have, and by if someone's on disability, they have to reevaluate you just to make sure.
Yeah, Social Security for some reason doesn't have any permanent, even though we know there's permanent disabilities are not going to get better, they actually have to re-review everybody at some point in time. But most reviews are actually called mailers, where they're just sending you a form asking you if your medical condition has improved, and once you fill that out and complete it, you're fine. The minority are the ones they actually do the full medical reviews on, and that's where they expect there to be medical improvement, and then they'll actually get medical records and really evaluate to see if your condition has improved. And they do have to show significant improvement in order to say you no longer meet the definition of disability.
So one thing people ask, so what do I have to do to get approved? So as I was saying earlier, the first thing is you want to talk to your doctor. You need your doctor's support to garner the favorable results you're looking for. The other thing is to be careful when you get the application forms. If you're going to do it yourself, although I'd recommend you get help, but if you're going to do it yourself, be careful what you say in those answers. Because a lot of times people, I like to joke, people say the darndest things in these applications. And sometimes they'll say, well, I'm looking for disability because I cannot do my past job. And Social Security will jump all over that, and they'll say, well, you can't do your past work. However, we think you can do some other easier type of work. So you want to be careful what you put down. And no matter what you put in an application, Social Security is going to make the determination based on the medical evidence, most likely. However, despite the medical evidence, if you put something down there that makes it appear that you can do some sort of work activity, they might take that and use that against you. I think there's another question on here that says, I have trouble reading it.
Yep, what happens during the psychological evaluation and why do they happen?
Well, obviously when someone is unable to work and they're suffering a life-threatening illness of any type, often folks become depressed as well. So many times what Social Security will do, it's their job and their role, they have to evaluate all the potential impairments that someone might have. So even though someone might be alleging disability as a result of the aortic condition, oftentimes people get depressed in that situation. So what they'll do many times is they'll set up an independent consultative medical exam. There's some pipes making funny noises in the room, so we apologize if you can hear that. So yeah, if you have your own psychologist or psychiatrist you're treating with, then you would go ahead and they would submit the evidence for it. But if the Social Security sets you up for an exam, I would certainly attend it because sometimes if you do not attend a consultative exam that they set up, they'll make a determination, sometimes use that against you, that you're not willing to see their doctor. But the first choice should be your own doctor, of course. Hopefully that answered the question.
Do we have any other questions out there? All right, I'm going to look and see who we have on here. Oops. It's not letting me do. Yes, I do. As the sounds around the office got a little louder, I got a little laughter.
Yeah, you people probably couldn't hear it, but there were some unique sounds coming from this room. So I apologize for that.
All right.
The other thing that will happen when you file an application is many times someone will they'll send you more forms to describe your work activity, what your job is, what you do on a day-to-day basis, and these have to be also answered carefully because sometimes we have a tendency as humans to puff up what we do for work, and if you demonstrate you have more skills than you really do, sometimes Social Security will use that against you, saying, well, you have these skills, can transfer to an easier job.
All right, we got a few questions here. The first one I saw was, what if someone hasn't worked the required number of hours? What that means is, in order to be eligible for Social Security, you have to have paid enough into the program to be eligible. And it's really based on two factors. One is how old you are. The younger you are, the less work you need to have. And then the other one is what's called disability insured status, which means you have to have worked in the recent past to the point you became disabled. You have to have paid enough in to be eligible, because Social Security is referred to as an entitlement program, which means you pay for it. So you have to have paid enough in. So if you don't have enough work under Social Security, then you would not be eligible for it. So there is a requirement to have that. However, it's relatively low. If you've had consistent work, even not at a high rate, you most likely are eligible. So most people are insured for Social Security that have a decent work history. And then I see a question. I'm fighting now with a lawyer and still getting told no. All right. So that's really the fact that Social Security, for the most part, most people are going to have to go to that hearing level of appeal. So I'm assuming that you're going through that process, and you probably have filed at the initial level and you've been denied. You filed at the reconsideration level, you've probably been denied, because again, only 13% of everybody who files at that level. Now you get to the hearing level. This is where you have your best chance and your best opportunity to be awarded. And I'm sure that your attorney that you're working with right now has gathered all of your medical, has prepared a case. You're probably waiting for that date, and that is going to be your opportunity. And just remember that when you're there, your attorney's going to prep you for this, but the point is, when you're asked questions, is all to relate how your disability is affecting your ability to work. That's what really matters, how it's affecting the fact that you couldn't hold an 8-hour job in even a sedentary type position. So that's what all the questions and everything is getting at. That's the crux of it. And so I'm sorry it takes so long. Unfortunately, that's the process with Social Security right now. It is very difficult to get awarded, and the best chance of being awarded is at the hearing level.
I see, Amanda, that you mentioned that you also have Marfan syndrome, which has led to your problem. Of course, Marfan's is a connective tissue disease, as you know, and it affects many body systems. So I would think the move there would be make sure you or your attorney talks to your doctor and have them go ahead and basically explain all the things that are affecting you.
Okay. What's this one? I have TAA 3.6 cm and arteriosclerosis,
COPD. Get denied at hearing because I smoke and obese. Is that normal? Well, unfortunately, what happens often is many times when someone has heart disease and they continue to smoke, sometimes some judges will use that against them. And I remember this vividly. I was on a case out in Oklahoma City, and there was a claimant had some very severe heart and lung issues, but he still smoked a lot. And I said, that's going to be a problem. We went in there, and the judge said, you know what, I've tried to quit too. I've never been able to quit, so I understand what you're going through. I'm going to grant benefits. And I told him he was extremely lucky, because unfortunately that's the rare instance. More often than not, for some reason, some judges take a holier-than-thou attitude sometimes if someone is either smoking or if someone is drinking and that is contributing to their problems. Sometimes they will use that against them, which can be unfortunate, because I think, obviously, Nancy, in your situation, if you were to stop smoking, it might help you, but it obviously wouldn't cure all your problems and make you suddenly able to work.
Yeah, and with that said, they do release award statistics based on judges, and they're far from equal. So sometimes, unfortunately, it's almost less to do with what condition you have and more to do with the judge that you get. And that's not the way it should be, but in reality, sometimes that's what happens, because there are judges that award higher percentages than others that award a low rate, and so that could play a piece of it as well.
I see Amanda says that she picked up a job because obviously while you're waiting for this decision, hopefully it'll be in your favor. You need at least some income. So I would advise if you do pick up a job to have it only a little bit under that $1,220 gross a month. It wouldn't put you over that substantial gainful activity level. And people ask me a lot. They're in this tough situation. They say, "Well, should I try to work?" And I usually tell them, I think you should. And here's why. Because sometimes you go to a hearing and a judge will ask, well, when's the last date you worked? Oh, it was 2017. Have you tried any work at all since then? And sometimes you have to say no. And I just think of them, I see them thinking, and they're going like, okay, then you haven't even tried to do something easier or whatever it might be. So if you are able to go back to work and try a job and can do it, well, then that's great. That's what you want. You want to get back to work. However, if you try to work and fail, that also can be very strong evidence in favor of your case for disability, because you can say, well, I couldn't do my past job, Your Honor, and I tried to do this easier job. However, after 2 months, I found I couldn't do that either, and that somehow, gives you more credibility to your case.
All right, another question. If someone has been granted disability and 2 years later are being reviewed, now they have a growing aneurysm and had TIAs, etc., situation, but getting better, assuming the decision is in their favor, should this person be expected to be reevaluated every 2 years? It's stressful. Yeah.
It is. It depends on your age. In other words, if someone is 60 or 62 years old, that person probably will not get looked at again, because if they do look at them and turn them off SS disability, they can go on early retirement at Social Security. So they don't get the savings. The younger you are, the more likely you are to be reviewed. Now, it's not funny, but about 6 years ago, Social Security wasn't doing any reviews at all. They didn't have the budget to do so. And then there's some in Congress who were saying that, oh, too many people are on disability that shouldn't be. So what they did is earmarked a lot of money for these, what they call continuing disability reviews. And they've been doing them, and they've been basically catching up. So in answer to your question, if you reviewed just recently, I wouldn't worry about it every day, but you probably will be reviewed, especially if you're a younger individual, probably in the next 3 years or so.
But again, if nothing's changed, I mean, you're still disabled, then you're not going to have to, it's not going to be overturned. So they do have to show significant improvement in
Yes.
order for you to come off it. So if that can alleviate the stress a little bit, but I certainly understand getting reviewed is always stressful. All right, so we've had another couple questions. I've worked as an RN for 27 years. When I went on long-term disability through my employer,
I've applied twice and have been denied. They are saying I should do a, quote, less stressful job, both physically and mentally. If I decide to return to work at less hours or a position that paid less, won't I be hurting my benefits?
Okay.
Well, if you return to a full-time job, 40 hours a week, and did it, periodical and for a long period of time, then yes, that would hurt your case for ongoing disability. It sounds like you've already been out for 12 months, though. And if you're getting long-term disability, I would think that your long-term disability carrier might have set you up with someone already to assist you. If not, we might be able to help you. But certainly, and I kind of addressed that a little bit, if you were to do something less stressful and were able to succeed at it, then they might be right, then you might not, in fact, be disabled. However, with your underlying condition, the stress is going to be with you regardless of what you're doing, I feel, and that, even though you're not a full-time nurse anymore, whatever you're doing might still be not enough to be able to sustain it, if I'm making sense.
And in terms of reducing your future benefit, so when you eventually file for retirement benefits, so say you never file for disability, wait till retirement, retirement is going to take your top 30 years of work over your lifetime, and they're going to index all of your wages up to dollars of today. So you have 27 years of work already, which are probably, substantial work. So going down will affect it, but not as greatly as you might think, because remember, they're indexing all dollars to equal dollars of today, and they're coming up with your average monthly wage over your lifetime. So you've got 27 years of solid work. If you have to reduce your work for the last 3 years, it will impact it, but minimally, I would think, for the most part. So if that's your concern, I wouldn't be as concerned about that. It's more about making sure that you can work in a way that's healthy for you. That's great. But if it's not, and you're unable to maintain that, then you do want to file for Social Security disability.
And the other thing is, if you're getting long-term disability and you start work at another job, that could very well jeopardize you continuing to receive the long-term disability. So you want to be careful with that. I usually recommend folks that want to return to work within the same employer. So the LTD will stop, but if you're unable to do it, you'll go right back on. If you go to another employer and the LTD will stop, you might not be able to get back on it.
Yeah,
so
you could have a pre-existing condition at that
Right.
point. Yeah. All right. Talk to us about if a claimant has a child under the age of 18. Oh, you want me to go with that? I'll go with that. All right. So if I become disabled or retired, regardless of what type of benefit I receive, if I have children under the age of 18, they're eligible for a benefit on my record. A child's benefit would be 50% of my benefit amount. So if my benefit amount was $1,200 a month, if I have one child, they're going to get $600 a month. And their benefits will continue until they're 18, unless they're still in high school. And if they're still in high school, benefits can continue until they're 19 or they graduate, whichever's earlier. So it's really just 50% of my award. Now, if I have two children, it's not 600 and 600. They would get 300 and 300. So really, whether I have one child or 10 children, they're going to get a total of 50% of my award, and that's what they're eligible for. All right.
Here's another question here that someone asked, Nancy asked, what are my chances to appeal a judge's decision and get it overturned? The options there are to take it to you have two options. You could take it to the appeals council and and hope the judge made some mistakes in law or in fact that your attorney can point out and overturn. However, I must say the appeals council rate of getting cases overturned is quite low. However, it does happen. And then should it be denied again at the appeals council, which is the fourth step at the Social Security level, you do have the option to take it on into federal district court. And we've had some good success in doing that for the appropriate cases. The courts and the appeals council gives great deference to the judge in the decision that they make. They have to, you know how they talk about criminal law, it's going to be beyond a reasonable doubt, that standard, and then there's a 51-49 preponderance of the evidence standard. Social Security is even less than that. It's called the substantial evidence test. So you could have only 40% of the evidence going one way, and the judge could accept that to deny your case. So hopefully in your case, Nancy, the judge made some mistakes that were clear, in the law, or he didn't count all the facts that are in your favor. But I would talk to your attorney about that and go over it carefully with the attorney who's been knee-deep in that case and follow whatever advice they would have. The other option is you could file a new application if you think there's no chance of winning the one that was just denied. However, whenever you do that, you won't go far back retroactively. You can only go back to the date after the judge made that negative decision on you.
All right, any other questions? Something else coming through here? Can you work? Yes, so we were just asked if we can work with anyone nationwide, and yes, we can. We have, we're a firm that represents everyone in every state, so wherever you are, from Alaska to Hawaii to Maine, we would represent you in person if we had to go to the hearing level, but hopefully we'd get you awarded before going to the hearing level, so we are able to do that. And another question.
Yeah, well, this question asks, can you explain again how the attorneys are paid? I think community members feel they can afford an attorney. Yeah, that's a very good question. The attorneys are paid on what they call a contingency basis. In other words, they only get paid if your case is approved. So you only want to go with an attorney. Don't go with an attorney who's looking for money up front. That should not happen. Whenever we represent someone, we are in it with them. We either win together or lose together. So Social Security has a standard fee agreement, and Social Security, by the way, must approve any fee that an attorney will charge. So that fee agreement calls for the fee to be 25% of the past due benefits up to a cap or a maximum of $6,000. So 25% up to $6,000 what the attorney would get. And again, it's contingent on you getting awarded your benefits. So that's a good question. And really, I would run away from any attorney who wants any money up front from you.
All right, another question here.
Yeah, this is Nancy saying you didn't put emphysema and scarring on my lungs, and oh boy. So even though it sounds like the judge in making their decision did not, focus on all the contributing factors to your disability, and that's a common mistake because sometimes judges are human. They're under pressure to do 50 decisions a month or so, and sometimes they'll make up their mind they're going to deny a case, and they want to deny it. But in so doing and in making the determination and putting in the pen to paper, they don't do it in an effective way. And that's what you want to look very carefully at. And it sounds to me like they certainly left out some major issues regarding your case, Nancy.
Does getting benefits for a child take as long as it did to get disability for yourself? No, definitely not, because there's no medical determination that needs to be made. So once you've been awarded, as soon as you can prove to them this is your natural child, so provide a birth certificate, or if a stepchild or adopted child, once you provide that proof to them, then they should be able to just process it and put it into pay. It can take usually a month or two, and the only reason is just because they're so backlogged. What they need to do is also make a person be the representative payee for the child, and usually it's the parent. So if it was you, then you would be the person that would get the checks on behalf of the child, and that's merely answering some questions and signing a form. So it's just providing proof that you are the parent of the child, filling out an application, signing it, and then it can go right into pay. So it should not take as long, absolutely not as long as it took to get disability, and it should really be done within a couple of months.
Yeah, we battle with Social Security all the time, and they make a lot of mistakes when it comes to making kind of subjective disability determinations. But once you're awarded and approved for disability, they're pretty darn good. Social Security is at paying, obviously, you and then any dependents. They pay them fairly promptly and accurately. So.
All right, another question here says that It can be very overwhelming with the amount of questions and forms, and some people have had strokes and cognitive disabilities. Do we work with that? Absolutely.
Yes. Yeah, that's we like to say we're going to take the stress out of the situation, and we tell our claimants, listen, you worry about feeling as good as you can, get your doctor's appointments, etc. Let us handle dealing with the bureaucracy that is Social Security. And Karen is exactly right that many times Social Security can overwhelm you with forms. I've been on this forum with doing a couple of these Facebook Lives more than once, and I might have told the story before, but my brother had an opportunity where he had a situation where he had applied for disability. He's my older brother, and he teaches at a university, and I said, hey, listen, I can do that for you, by the way. This is what I do. Oh, no, I'll take care of it. I can do it myself. Well, he called back like 2 or 3 weeks later. Well, I completed some forms, and I didn't get some others, and I got the same forms back. I don't know whether I've done it at all, so can you please help? And I thought, geez, if he's having trouble, what is the average person having trouble doing? So we pride ourselves in, yes, taking all that headache off you. We complete all the forms with you, either over the telephone or through back and forth through emails, whoever it might be. And we do this, one, to make sure it gets done, but two, to make sure it gets done in a way that's not going to hurt you later, too. Obviously, we're not going to put anything down that's untrue, but sometimes there's a way you present information that can make it appear in the best possible light.
Right. So we'll ask all the questions. We'll complete all the forms and then mail them to you for your signature, and then you mail them back to us. So one thing about having a representative help you is that Social Security should be doing all their communicating with us versus going directly to you. So again, you're not having to deal with the stress or those forms or making sure that you're meeting any deadlines or timelines and to get things done. Right. Any other questions out there?
We could talk all night on this stuff. I'm sorry, but
Sadly,
we can.
We could.
As long as Barb doesn't start laughing again.
Well, they stopped the noise. I'm good now.
And by the way, I know sometimes people are uncomfortable in putting questions out with their name in a semi-public forum like this. So I know the Aortic Hope puts our name and contact information out there, and feel free to contact either Barb or myself at any time, and we'll be happy to answer whatever questions you might have, and not this Facebook Live format.
Yeah, we are happy to. I know after we've done a few of these, I've received some phone calls and answered questions, and certainly people not expecting to work with us, which is absolutely fine. We're just here as a resource to you. All right, and this one says, thanks you so much. This will remain in our page. Feel free to check back here for additional questions. So we love doing this. Again, please don't hesitate to ask us any questions at any time, and I hope we'll be on again at some point to give you more information.
Yes, and good luck, everyone. We consider ourselves friends with Aortic Hope, and we'll check back, because I know questions come up over time. So,
all right,
good
thanks,
luck.
everybody. Have a good night.
Thank you.